Hello everyone. The topic for today's lecture is inspection and inquiry. The objectives of this lecture are to make the students understand about the concepts of inspection and inquiry under the Companies Act 2013, to discuss the trigger points of inspection and inquiry, and to discuss sections 206 to 209 of the Companies Act 2013. In last few decades, there has been a radical shift in the perception towards businesses and companies. A company's accountability on legal, economic, and social grounds has become vital for its growth and the country's reputation. In National Textile Workers Union and others versus P.R. Ramakrishnan and others, the Supreme Court of India noted how the doctrine of laissez-faire is fading away, and that a company is now no longer a mere profit-making enterprise, but it has assumed the role of a social institution. The court recognized a company as a species of social organization with a life and dynamics of its own and exercising its significant power in contemporary society. There is clear and a close relationship between corporate governance and ethics, but conflicts between the two is certain. Such conflicts, if not taken care of, reduce the confidence of potential investors and affect the global credibility of the government. Keeping the same in mind, the law on inspection, inquiry, and investigation of companies has been tightened. The main objective of an investigation is a form of deeper probe into the affairs of a company. It is a fact-finding exercise to collect evidence and to see if any illegal acts or offenses are disclosed and then decide the action to be taken. It's only efficient and smooth functioning of the corporate that can ensure an adequate return on capital invested by the shareholders. Thus, with the introduction of Chapter 14, that is Section 206 to Section 229 of the Companies Act 2013, companies are now forced to introspect and leave no stone unturned. This chapter deals with the provisions relating to inspection, inquiry, and investigation of the affairs of companies and are thus very critical towards building an environment of good corporate governance. Under this chapter, the main objective of the central government was to protect the interests of shareholders so as to maintain transparency so that shareholders can inspect, investigate, or inquire during situations where it could be mirrored that business of the company was done in a fraudulent and unfair manner. In today's lecture, I will be dealing with inspection and inquiry only. In general terms, the term inquiry means an act of asking for information and inspection means carefully examination or scrutiny. The provisions related to inquiry and inspection is equally applicable to all companies irrespective of whether the company is a public company, private company, small company, one-person company, government company, or foreign company. Now the question arises that what is the trigger point of inquiry and inspection? The trigger point for any inquiry is the opinion formed or made by the registrar after scrutiny of any document filed by a company or on the basis of any other information received by him, and accordingly the registrar must be of the opinion that further information or explanation is necessary. The trigger point for any inspection is the opinion formed or made by the registrar after an inquiry conducted that the business of a company is being carried on for a fraudulent or unlawful purpose or not in compliance with the provisions of this Act, or if the grievances of investors are not being addressed, or when central government is satisfied that the circumstances so warrant. Section 206 to 209 of the Companies Act 2013 deal with the aspect of inspection and inquiry. Once the trigger point for an inquiry was made, the registrar may issue a written notice requiring the company to furnish in writing such information or explanation or to produce such documents within such reasonable time as specified in the said written notice. Section 206 of the Companies Act 2013 talks about the power of the registrar to call for information, inspect books and conduct inquiries. Subsection 1 of Section 206 says that where on a scrutiny of any document filed by a company or on any information received by him, the registrar is of the opinion that any further information or explanation or any further documents relating to the company is necessary, he may, by a written notice, require the company to furnish in writing such information or explanation or to produce such documents within such reasonable time as may be specified in the notice. According to subsection 2, on the receipt of a notice under subsection 1, it shall be the duty of the company and of its officers concerned to furnish such information or explanation to the best of their knowledge and power and to produce the documents to the registrar within the time specified or extended by the registrar, provided that where such information or explanation relates to any past period, the officers who had been in the employment of the company for such period, if so called upon by the registrar through a notice served on them in writing, should also furnish such information or explanation to the best of their knowledge. According to subsection 3, if no information or explanation is furnished to the registrar within the time specified under subsection 1, or if the registrar on an examination of the documents furnished is of the opinion that the information or explanation furnished is inadequate, or if the registrar is satisfied on a scrutiny of the documents furnished that an unsatisfactory state of affairs exists in the company and does not disclose a full and fair statement of the information required, he may, by another written notice, call on the company to produce for his inspection such further books of account, books, papers, and explanation as he may require at such place and at such time as he may specify in the notice, provided that before any notice is served under this subsection, the registrar shall record his reasons in writing for issuing such notice. According to subsection 4, if the registrar is satisfied on the basis of information available with or furnished to him or on a representation made to him by any person that the businesses of a company is being carried on for a fraudulent or unlawful purpose or not in compliance with the provisions of this Act, or if the grievances of investors are not being addressed, the registrar may, after informing the company of the allegations made against it by a written order, call on the company to furnish in writing any information or explanation on matters specified in the order within such time as he may specify therein, and carry out such inquiry as he deems fit after providing the company a reasonable opportunity of being heard, provided that the central government may, if it is satisfied that the circumstances so warrant, direct the registrar or an inspector appointed for it for the purpose to carry out the inquiry under this subsection, provided further that where business of a company has been or is being carried on for a fraudulent or unlawful purpose, every officer of the company who is in default shall be punishable for fraud in the manner as provided in section 447. Now, according to section 447 of the Companies Act 2013, any person who is found to be guilty of fraud shall be punishable with imprisonment for a term which shall not be less than 6 months, but which may extend to 10 years, and shall also be liable to fine, which shall not be less than the amount involved in the fraud, but which may extend to 3 times the amount involved in the fraud. Where the fraud in question involves public interest, the term of imprisonment shall not be less than 3 years. Talking about the meaning of fraud, Explanation 1 to Section 447 has defined fraud in relation to affairs of a company or any body corporate to include any act, omission, concealment of any fact, or abuse of position committed by any person or any other person with the connivance in any manner, with intent to deceive, to gain undue advantage from, or to injure the interests of the company or its shareholders or its creditors or any other person, whether or not there is any wrongful gain or wrongful loss. Wrongful gain in terms of explanation second means the gain by unlawful means of property to which the person gaining is not entitled. On the other hand, explanation third to Section 447 has defined wrongful loss to mean the loss by unlawful means of any property to which the person losing is legally entitled. According to subsection 5 of Section 206, without prejudice to the foregoing provisions of this section, the central government may, if it is satisfied that the circumstances so warrant, direct inspection of books and papers of a company by an inspector appointed by it for the purpose. Subsection 6 says that the central government may, having regard to the circumstances by general or special order, authorize any statutory authority to carry out the inspection of books of account of a company or class of companies. Subsection 7 says that if a company fails to furnish any information or explanation or produce any document required under this section, the company and every officer of the company who is in default shall be punishable with the fine which may extend to 1 lakh rupees, and in the case of a continuing failure with an additional fine which may extend to 500 rupees for every day after the first during which the failure continues. In VV Renewable Energy Private versus the Registrar of Companies, Madras High Court held that Section 206 of the Companies Act 2013 gives the Registrar of Companies the power to call for information, inspect books, and conduct inquiries in respect of any company. Under Section 206 of the Companies Act, the Registrar of Companies is required to issue a written notice and provide an opportunity to the company to show cause and respond to the request for documents or information or explanation. Now, Section 207 of the Companies Act 2013 talks about the conduct of inspection and inquiry. Subsection 1 of Section 207 says that where a registrar or inspector calls for the books of account and other books and papers under Section 206, it shall be the duty of every director, officer, or other employee of the company to produce all such documents to the registrar or inspector and furnish him with such statements, information, or explanations in such form as the registrar or inspector may require, and shall render all assistance to the registrar or inspector in connection with such inspection. Subsection 2 says that the registrar or inspector making an inspection or inquiry under Section 206 may, during the course of such inspection or inquiry, as the case may be, make or cause to be made copies of books of account and other books and papers, or place or cause to be placed any marks of identification in such books in token of the inspection having been made. Subsection 3 says that notwithstanding anything contained in any other law for the time being in force or in any contract to the contrary, the registrar or inspector making an inspection or inquiry shall have all the powers as are vested in a civil court under the Code of Civil Procedure 1908 while trying a suit in respect of the following matters, namely, the discovery and production of books of account and other documents at such place and time as may be specified by such registrar or inspector making the inspection or inquiry, summoning and enforcing the attendance of persons and examining them on oath, and inspection of any books, registers and other documents of the company at any place. Subsection 4 says that if any director or officer of the company disobeys the direction issued by the registrar or the inspector under this section, the director or the officer shall be punishable with imprisonment which may extend to 1 year and with fine which shall not be less than 25,000 rupees but which may extend to 1 lakh rupees. If a director or an officer of the company has been convicted of an offence under this section, the director or the officer shall, on and from the date on which he is so convicted, be deemed to have vacated his office as such, and on such vacation of office shall be disqualified from holding an office in any company. Now talking about Section 208 of the Companies Act 2013. According to this section, the registrar or inspector shall, after the inspection of the books of account or an inquiry under Section 206 and other books and papers of the company under Section 207, submit a report in writing to the central government along with such documents if any, and such report may, if necessary, include a recommendation that further investigation into the affairs of the company is necessary, giving him reasons in support. Section 209 talks about search and seizure. Where upon information in his possession or otherwise, the registrar or inspector has reasonable ground to believe that the books and papers of a company or relating to the key managerial personnel or any director or auditor or company secretary in practice of the company has not appointed a company secretary are likely to be destroyed, mutilated, altered, falsified or secreted, he may, after obtaining an order from the special court for the seizure of such books and papers, enter with such assistance as may be required and search the place or places where such books or papers are kept, and seize such books and papers as he considers necessary after allowing the company to take copies of or extracts from such books or papers at its cost. The registrar or inspector shall return the books and papers seized under subsection 1 as soon as may be, and in any case not later than 180th day after such seizure to the company from whose custody or power such books or papers were seized, provided that the books and papers may be called for by the registrar or inspector for a further period of 180 days by an order in writing if they are needed again. Provided further that the registrar or inspector may, before returning such books and papers as aforesaid, take copies of or extracts from them or place identification marks on them or any part thereof or deal with the same in such other manner as he considers necessary. The provisions of the Code of Criminal Procedure 1973 relating to searches or seizures shall apply mutatis mutandis to every search and seizure made under this section. To illustrate, a group of creditors of ABC Trading Limited makes a complaint to the Registrar of Companies, Mumbai, alleging that the management of the organization is indulging in destruction and falsification of the accounting records. The complainants appeal to the registrar to take immediate steps to seize the records of the enterprise so as to prevent the management from tampering with the records. The complaint was received at 10 a.m. on 1st July 2021 and therefore the Registrar of Companies entered the premises at 10:30 a.m. for the search. Now examining the powers of the Registrar here to seize the books of the company consistent with the provisions, Registrar may enter and search the place where such books or papers are kept and seize them only after obtaining an order from the special court. Since within the said question, Registrar entered the premises for the search and seizure of books of the concern without obtaining an order from the special court, he is not authorized to seize the books of the ABC Trading Limited. Now, talking about the penalty for furnishing false statement, mutilation or destruction of documents, Section 229 of the Companies Act 2013 says that a person who is required to provide an explanation or make a statement during the course of inspection, inquiry or investigation, or an officer or other employee of a company or other body corporate which is also under investigation, destroys, mutilates or falsifies or conceals or tampers or unauthorized by removes or is a party to such destruction, mutilation or falsification etc. of documents relating to property, assets or affairs of the company or the body corporate. Secondly, makes a party to making a false entry in any document concerning the company or body corporate, or provides an explanation which is false or which he knows to be false, he shall be punishable for fraud as provided in Section 447. To conclude, the importance of inquiry and inspection is that inquiry indicates need for deeper examination of the books of account like volume of records. Inspection helps in collection of evidence and recording of statements. Inquiry strengthens information in registry or to fill the missing gaps or incomplete fillings. Inquiry is helpful when there are doubts on existence of the company. Inquiry redresses grievances raised by investors or depositors or other stakeholders. Inspection is important because of the higher number or frequency of investor complaints. As mentioned in the Company Law Committee Report 133 of 1952, that is the Bhabha Committee Report, no law, however, well conceived or well drafted, can be altogether full and naive proof, and it is impossible for any law to protect the fool from the consequences of its acts or omissions. Nevertheless, we consider that it is the function of law to prevent dishonest and unscrupulous people from creating conditions and circumstances which will enable them to make fools of others. So, that was all for today's lecture. I hope that you have understood inquiry and inspection under the Companies Act 2013. Thank you for watching.